Is the court about to overturn Roe v. Wade, and how could we possibly know that in advance? Good morning, ladies and gentlemen. This is another declaration of truth from your host, Terry A. Hurlbut. This is part 2 of a 2-part video. We have an astonishing development in the case of Dobbs versus Jackson Women's Health Organization. Someone, we don't know who, yet actually leaked a document purporting to be a draft opinion of a justice of the Supreme Court. It seems to show that the court is ready to turn abortion law back to the states. Or is it? That leak is either the most serious, indeed shocking, breach of security in court history, or an elaborate fraud. And if it's true, and if that opinion becomes the majority opinion, get ready for the great sortation sooner than anyone could expect. That is, if someone didn't leak it deliberately to forestall that result. In part 1, I gave you the history of Roe v. Wade and how we got here. Now in part 2, we're going to talk about that document, whether it's real or not, and what its release really means. First, I want to shout out to the sponsor of this channel, which is Conservative News and Views, link in the description. And be sure to check out the awesome CNAV Store. Scroll down to the bottom for that link. Lots of good merchandise there, including this t-shirt, Rhino Hunting. And I want to remind you, I am a published author. Look for 2 new books, Matthew's Run, right here, and its sequel, Matthew's War. They tell the story of what our country and our world might look like after 380-odd years of wokeness, and about a cyborg with a conscience who also just doesn't like to be used, leading a rebellion against it. They're available right now at Amazon and Barnes & Noble, to name 2. All right, ladies and gentlemen, pay attention. Class will come to order. From history, we now come to forensic document analysis and a discussion of the implications. Politico.com alleges that they have a draft of an opinion by the court in the Dobbs versus Jackson case. I have a link in the description to that draft document. Now, this document purports to be a draft opinion by Justice Samuel A. Alito, that he or his clerks stamped for circulation to the other 8. This is how appellate courts decide the matters before them. They typically do not meet in conference. Instead, each justice writes his own draft opinion and sends it around for his colleagues to read. Only after this does the presiding judge poll his panel and then assign someone in the majority to write an opinion. That person's colleagues can join him, write their own concurring opinions, or write dissenting opinions. This battle of the opinions explains why the public must typically wait until June for a decision. The circulation stamp on this document reads, circulated February 10th, 2022. That's consistent with the heading at the top, first draft. Politico provides no provenance on this document except this statement. I quote, Politico received a copy of the draft opinion from a person familiar with the court's proceedings in the Mississippi case, along with other details supporting the authenticity of the document. Unquote, Politico. Well, the ubiquitous Mr. Piffwitz, that's person familiar with the situation, makes yet another appearance. A different Mr. Piffwitz alleged the following. Justices Barrett, Gorsuch, Kavanaugh, and Thomas have already decided to join Justice Alito. Justices Breyer, Sotomayor, and Kagan are preparing dissents. Chief Justice Roberts must still be trying to decide. Folks, I have a problem believing this document is real. Now, for what it's worth, the Supreme Court's homepage still lists Justice Stephen G. Breyer as a member of the court. But Justice Ketanji Brown Jackson won confirmation on April 7, 2022. Now, perhaps Justice Jackson will take up her duties this fall. In any case, she would not have been qualified to write any opinion back in February. But you want to know the biggest problem with this document? No one has ever leaked a draft opinion of the court before today. It represents the most serious and egregious breach of court security in court history. Either that or it represents a fraud on the public and on the body politic. Now, you can't keep a lid on a thing like this. It's all over the internet. The Blaze and the site We Love Trump, to name 2, have stories. These and other secondary sources rely on Politico.com, but a large number of Twitter accounts, including many verified or blue checkmark accounts, have covered the story also. No need to link to the tweets. You can follow the link to the CNAV article anyway. It has them. I'll just tell you whom they're from. We have the Daily Beast, Tim Pool. Now, you might want to keep the kids away from that one. Such language. Disclosed TV and Jack Posobiec. Now, let me emphasize the extreme likelihood that someone, maybe one or both of these Messrs. Piffwits, or maybe Politico.com themselves, are perpetrating a fraud on the body politic. Anyone can search Oye.com or some other database for example of Justice Alito's justicial prose. Therefore, anyone can forge his opinion. Note especially that the document bears no signature, but only a circulation stamp with a date, but not a time. I already hear you asking, why would anybody do a thing like this? Well, who knows why? Maybe the Messrs. Piffwits wanted to sabotage Justice Alito's work. More on that later. Or maybe they did it to get their 15 minutes. Or Politico.com ginned the whole thing up as clickbait, and that included the writing of an opinion that looked real. Either that or somebody stole a hard copy of the draft opinion from a justice's desk in chambers, ran off a copy in the court copying machine. Does that machine have a register of how many copies it made and when? Then put the original back on the desk so that the justice involved wouldn't notice, and then gave or sold the copy to Politico.com. And who can tell whether it wasn't Justice Kagan or Sotomayor who did it? Now, I doubt that Justice Breyer would do something like this. Stranger things have happened in this country, including the recent establishment of an Office of Truth in the Department of Homeland Security. Now, whoever wrote this document clearly did his homework. The authorities the document cites are simple enough to check. They include Roe v. Wade, of course, along with 31 other abortion laws that Roe invalidated. Furthermore, the document shows classic Samuel Alito style. He accuses the original Roe court of, to say the least, sloppiness, and to say the most outright lies. Constitutionally irrelevant and plainly incorrect. Them's fighting words. They tell of a justice who would throw stare decisis, that's fancy Latin for let it stand as decided, to the winds. But they also reveal an author who believes that if anyone has damaged the dignity of the court, then it is the predecessors of the present court members, especially in the Roe and Casey cases. If Samuel A. Alito did not write this opinion, then someone has done a first-rate job imitating him. The author's citation of Washington versus Glucksberg, 1997, is a stroke of genius. Here we have a Jack Kevorkian style case. Jack Kevorkian is the one who became a folk hero for practicing and advocating for physician-assisted suicide. The court came down against such practice 9-0. It held that the Due Process Clause protects two kinds of rights only. These being rights one can find in the Constitution, or that are deeply rooted in history and tradition and implicit in the concept of ordered liberty. Well, that's exactly the sort of authority Samuel Alito would cite. So, what can we expect? Is Roe v. Wade fallen? Not so fast! Maybe whoever leaked this document intended the opposite effect. The court has no comment on the breach thus far, but you know the court will meet in conference very soon, maybe as early as today. I guarantee you that anyone standing out in that hallway is going to hear a lot of ranting and raving and screaming at the top of everyone's lungs. The court might decide to disqualify Alito from any decision in the case. Maybe they'll blame him for the leak. Then Robert C.J. votes with Breyer, Kagan, and Sotomayor J.J. Result, a 4-4 tie, and the decision of the Fifth Circuit stands. Roe v. Wade stands, and the Gestational Age Act falls. And this would happen for one reason only, to teach the public a lesson about stealing draft court opinions. I've had instructors revise lesson plans after someone sneaked a peek at them to anticipate homework assignments. The court could decide that its collective honor and prestige require it to take a similar course. Even without such a scenario, Gorsuch or Kavanaugh might decide to change his opinion, again, just to teach people a lesson about wrongfully sneaking a peek. The non-action by the court in Texas versus Pennsylvania, 2021, shows that court members do not seem to care about the implications of their actions. The only two that reliably do are Alito and Thomas. One can only hope that this is not the case, while duly noting that it could all be a fraud. Links to the description of the article, to the original Politico story, to the document purporting to be a draft opinion, and to conservative news and views. I have another link to the awesome online store, as I mentioned. And if you like what you've heard, you can like this video and subscribe to this channel. This is Terry A. Hurlbut delivering another declaration of truth and reminding you to let the truth set you free.